Hi there, welcome. This is the Employment Law Show, back once again. So good to have you along with us for the next half hour. Please stick around. Anytime during that half hour you want to reach out to Lior Samfiru, employment lawyer, alongside with me every week. You can do so. He's been doing this for decades, so you're in good hands. That number 1-855-821-5900. help@employmentlawyer.ca is the email address we will refer to in the show today. Samfiru, Tumarkin, Lior, co-founding partner of that particular firm across Canada, help tens of thousands of people get the severance they deserve and just deal with employment matters overall. In fact, they're the most positively reviewed law firm in the entire country. How about that? The duty to accommodate, true or false, is what's going to be the topic a little later on, Lior. You can't ask me like you used to. You used to punish me a few years ago in the show and put me on the spot, but I have the notes, so you can't do it anymore. So I'm going to ask you these questions and you can answer them because you are, after all, the lawyer. We'll get to that. We'll get to some phone calls from our radio show, which runs across the country. I'll give you details on how you tune into that every week as well. But we always start off with the week that was, pal. What do you got for me?
I won't put you on the hot seat today, John. I'll take the hot seat to myself, and I'll answer those questions, and hopefully I get those right. But great to be here, as always, to talk about employment law and hopefully solve some problems or at least alleviate concerns. And it can be very frustrating and stressful when you think that there's nothing that you can do, that you're boxed in, you don't think you have any rights, maybe your employer gave you an ultimatum. I know the stress that that causes. The thing is this, though. You have rights. You may not know what those rights are. There's a way out of the box that you think that you're in. Well, on this show, including what we do on our radio shows, is we show you that path out. We show you the options. We tell you what you can do if you find yourself in a difficult workplace situation. So we try to cover as much as we can on the show, but if we can't or we don't get to address your specific question, your specific situation, I can almost guarantee you that it's something that I've seen, I've addressed, and I'm quite familiar with. So try me. Call me at the office or email me. We'll give you that contact information throughout the show so we can have that private discussion and you can get some help with your legal issue and understand your rights at a bare minimum. That's the name of the game. You have a right to know what your rights are. And let's start by giving you an example of someone that didn't necessarily know their rights, but I spoke to them and now they at least know what they can do. So this particular gentleman found himself in what I can only assume was a very frustrating situation for him. For a period of about a year or so, he had worked consistently extra hours to help his employer. His employer was short-staffed because of the pandemic. And this person, being the good soldier and the good employee, very dedicated employee, worked significant amount of hours. And all he was hoping to do is to get paid his overtime that he's legally owed. And time again over that year, he spoke to his employer about overtime. Well, can you pay me overtime? I'm working, I'm helping you out. I'm not spending time at home with my family because I want you, employer, to be okay. Where's my overtime? Well, we can't really afford it, but we'll make it up to you somehow. Don't worry, I'll be fine. It's all going to even out in the wash. So he took the employer at its word. But after about a year of not getting anything and still being expected to work these crazy long hours, he called me just to understand what his rights and options are. So let's be clear, and here's what I told him. He has to get paid that overtime, okay? If he works overtime hours, in this case over 44 hours a week, he has to get paid time and a half. The fact that he was on a salary does not change that. He still has to get paid time and a half for hours over 44. There's no way to the employer to avoid that. The fact that the company says they can't afford it is not an excuse. If you have an employee that's working, you have to pay them what the law says. So, number one is certainly we can make the company pay the overtime. That's easy. But there's something else here. Because of the breach of law that the employer engaged in, they breached the law by not paying overtime that they were supposed to, he can actually treat the situation as a constructive dismissal. His employer simply is refusing to pay what it owes. He doesn't have to accept that. He doesn't have to continue working in that situation. In fact, he can choose to treat that as a termination of employment and get severance. So he's deciding right now whether he's just going to go after the overtime or pursue constructive dismissal as well. But I wanted to remind everyone there, certainly with respect to overtime, you have to get paid if you work it. By the way, you have to get paid the overtime even if your employer did not ask you to work it, but you worked because you had to get the job done. They have to pay you that overtime. And of course, if your employer refuses or doesn't pay you vacation pay properly, holiday pay properly, they don't calculate your wages properly, they breach the law and they won't fix it, and it happens regularly, you may be able to look at this as constructive dismissal. You can say, enough is enough. I don't have to be treated this way. I don't have to wait and try to convince you to pay me what you legally owe me. If your employer doesn't pay what they owe you, that absolutely can be constructive dismissal.
Really, really interesting case, Lior. Question number one, you said this employee went on for about a year without getting paid his overtime. How far can he go back if it was over a year?
Yeah, he actually can go back 2 years to get his overtime, so he's absolutely fine still. You know, if he was doing it for 3 years, then he would have lost that first year that he was working overtime. But he can go back 2 years. So for him, he's absolutely going to get paid the full overtime that he worked.
You mentioned in this, whatever jurisdiction he was in, it's 44 hours when that overtime clock starts ticking. Some of our viewers may be going, yeah, but Lior, I'm a salaried employee. Hours mean nothing to me. I just work for what I work for a year. How does that calculate?
So depending on your jurisdiction, whether you're BC, Alberta, or Ontario, there's a different overtime threshold. You know, for him, he was in Ontario, it was 44. Other provinces, it's different. But if you work more than your overtime threshold, let's say the threshold in your jurisdiction is 40 hours, your salary is good for up to 40 hours. So if you get paid a weekly salary, we divide that salary by 40. That gives us an hourly rate. Anything over and above that is calculated at time and a half. So it's as simple as that. Bottom line is you have to get paid overtime, even if you're on a salary. Your employer can't say, no, that salary includes overtime. It does not. You have to get paid time and a half.
Okay, one more because I'm driving you nuts, but it's interesting. Overtime's always an interesting topic to me. You mentioned the employer, even if he wasn't asked to do the overtime, but he had to do it to get the job done, still has to get paid for it. What if the employer says, guy, stop working the overtime. I don't want you to do it, but he still has to get it done. So he works the overtime anyway. Does he get paid? Can he get in trouble?
Oftentimes employees are between a rock and a hard place. They're told not to work the overtime, but
Right.
they know that if they don't get the job done, they'll get into trouble. So bottom line is, if you work it and it's legitimate, your employer has to pay for it, even if they told you not to do it. They told you not to do it, but you did do it anyway. You're a good employee. You want to work. You want to make sure the job gets done. Your employer has to pay for it. They can't avoid paying you overtime if you worked it just by saying, we told you not to. Even then, they have to pay.
Lior and I host a bunch of radio shows across the country, as Lior mentioned there a short time ago, right from Ontario to BC and Alberta as well. You want to go to employmentlawyer.ca, hit the media tab, find a station in your community where you can catch our show. We get a lot of phone calls in the show. People have questions. They send emails. They call into the show as well. We want to play one of those phone calls now, Lior, and dissect it a little bit.
The company has a contract with a certain distributor. Their contract has been changed, and I've been on this contract for the past 8 years, and now my pay has dropped by 30 to 40%. Regardless of that, they're still on a hiring spree to bring on more drivers.
Did your pay always fluctuate, or was it always consistent?
It was always consistent, $80K a year.
Listen, anytime we're looking at a pay reduction, as in this case, up to 40%, that is illegal. Generally, John, if an employee gets a pay cut of more than 10%, we're in constructive dismissal territory. So, a pay reduction of 5% is not going to make you happy. Who would be happy in that situation? But it probably doesn't rise all the way to the level of constructive dismissal. Once we're at above 10%, we're now talking constructive dismissal. This person, 30 to 40% reduction, absolutely constructive dismissal, not even a question. So his options are this. He can accept a new reality. He's making less money. Of course, if he does that, he potentially gives the company the right to reduce his pay again in the future. So that's option one. Or you can choose to look at this as a constructive dismissal. You've terminated my employment, Mr. or Mrs. Employer, by reducing my pay. Now I'm leaving. You have to pay me severance. How much severance? Well, let's see how much severance this person is actually owed. And if you're not familiar with it, what I'm going to be doing right now is using our severance calculator tool, used by already 2 million people. You can find it at pocketemploymentlawyer.ca. So let's take this person's contact information and particulars, and let's do the calculation. Let's see how much he's owed. So we know that he's a driver. He's been there for 8 years. Say he's 46 years of age. Because he was constructively dismissed, how much severance would he be owed? You can see in the bottom of the screen that could be as much as 10 months of severance. 10 months. That's a significant amount of severance for someone who wasn't actually let go. He's just been constructively dismissed.
Right.
Same with you at home. whether you've been constructively dismissed or flat out have been let go, you must, in fact, understand how much you're owed, what the law says severance for you looks like. Easiest, fastest way to do that, pocketemploymentlawyer.ca, free and anonymous, so check it out.
And that calculation's based on the full and original salary, not the 30 to 40% reduction, yes?
Absolutely. So if he was making $50,000, then it was reduced. Well, the severance is going to be based on the $50,000 because you never accepted that reduction. So that means a significant amount of severance owed to him.
That may, that whole thing may come surprising to some employers thinking, well, I run the shop. If I decide to give you a pay decrease by 30 or 40%, it's my call. But as you often say in the show, as an employee, you can't turn around and say, well, you know what, boss, I feel like a 40% increase. How about we start that today? That's never going to happen, right?
It would be nice. And the reason why neither employer or employee can do that is because we have an agreement in place, whether it's a verbal agreement, whether it's an agreement that's been developed over the years, or maybe it's a written document. We have an agreement saying, I'm going to come into work, do this job, and you're going to pay me this much. Well, that means that your employer can't just change it, no more than you, the employee, can change it. And if the employer says, well, I don't care, I'm going to change it anyway, well, that's where it's constructive dismissal, because the employer is breaching the terms of employment.
Again, reaching out to Lior through email, help@employmentlawyer.ca. He has a wonderful team, answers these as well. I want to get to a very common one that we got recently, Lior. Says, I was permitted to work from home during most of the pandemic. I've since undergone knee surgery, and now I'm hearing we'll be called back to the office soon. I'm not able to travel as I'm in recovery. Can I request to remain at home?
So generally speaking, if during the pandemic you were working from home because of the pandemic, your employer is able to say, now that things have eased up a bit, we can require you to come back to work. So generally speaking, your employer can tell you to come back to the way things were pre-pandemic. But this person has a medical condition, potentially a knee issue, that prevents him from being able to do so. So all he needs is a doctor's note to say that this person, because of a medical condition, can't come into the office either every day or at all, and needs to work from home. Once he has that doctor's note, the employer's obligation is to accommodate, to make it happen if at all possible. And if they refuse, that's a human rights violation. If they refuse, that could be a constructive dismissal, you name it. But you need that doctor's note. Whether it's to work from home or modified hours or modified duties, you have to have that doctor's note.
Interesting time to make that point as well, Lior, that your doctor has the final say. They're the gatekeeper of your health, and whether you need to be off work, it's not up to your employer, your boss, their boss. It's all about your doctor or your medical team in that case, right?
Your doctor holds the cards. Your doctor has so much say, and it's not possible really for the employer to question the doctor, to get a second opinion, to deny the doctor. If the doctor says you need something, the onus then shifts on the employer to figure out a way to make it happen.
Duty to accommodate, true or false? What is that all about? We'll cover it after a short break. In the meantime, here's the number, 1-855-821-5900 to reach Lior's team, and help@employmentlawyer.ca, and also the website, pocketemploymentlawyer.ca. Stick around, lots more coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back, Employment Law Show. We continue on here. John Scholes beside me, of course, employment lawyer Lior Samfiru. Samfiru Tumarkin LLP, as mentioned, the most positively reviewed law firm in the country. To reach out anytime, toll free, obviously, 1-855-821-5900, help@employmentlawyer.ca. Lior, we cover a ton of topics on our TV show weekly, on our radio show across the country weekly. One of those topics sometimes crops up is the duty to accommodate. You may be familiar with that term, maybe not, but we're going to dissect it here to pull back the curtain on this. In fact, it's going to be a duty to accommodate, true or false. I'm asking you. You're going to answer. Number one is this. A duty to accommodate, Lior, means an employer must provide support to an employee in certain situations. True or false?
Well, that term that you used, certain situations, is important, and that makes that statement true, because an employer doesn't necessarily have to provide support in all situations. It's in certain situations. So the duty to accommodate arises from our human rights legislation, and it says that in some situations, an employer has to provide support to an employee. And that means that they have to change the job or change the hours, do whatever they need to support that employee. Now, I say certain situations. So I'm going to give you an example. For, if you need your hours to be changed so you can make it to your son's hockey game, I think there's a good reason for the employer to do that. But legally, they're not required to. The duty to accommodate doesn't mean they have to accommodate your child's physical activities and game schedule. On the other hand, if you need to be able to take your child or yourself to the doctor because there's a medical condition, then the duty to accommodate applies there. So the most common times the duty to accommodate is triggered is when there's a medical condition. Number one is that's a very common one. There's a medical condition. You need support and help from your employer to ensure that your health is not impacted. The other common one is religious reasons. You may need not to work certain times or work certain hours so you can meet your religious obligations, maybe so you can be at a church or synagogue or mosque at a certain time. So that's a legal obligation under human rights that an employer has. But generally speaking, it's contained and refined and limited to those situations rather than in all situations.
Duty to accommodate, true or false? Number two, Lior, is this. To be accommodated, employees do not have to provide medical support or documentation from their doctors.
So we're talking, of course, about medical accommodation, and that statement will be completely false. It will be completely false because the way you trigger medical accommodation is with a doctor's note, as I said before the break. Your doctor holds the power to tell your employer what accommodation you need. It's perfectly appropriate for your employer, for your doctor to say to your employer that you need modified hours or modified duties or to work from home, to leave early, what have you, because that's what you need for medical reasons. So if you're looking for an accommodation, it's okay to tell your employer, here's what I need. But what you really need to do is to get that doctor's note. And the doctor's note, by the way, does not have to say what your medical condition is. That's irrelevant. Just that there is a medical condition and that you need accommodation. And by the way, that accommodation may simply be that you need time off work. That's okay too. Even that's something your employer has to do, but it all starts with that doctor's note.
That's an interesting sidebar. It's about prognosis, not diagnosis with your employer, right? They don't need to know whether it's a broken wrist, broken foot, cancer. That's not their business, right?
It's not their business. Their business is whether or not there's a medical issue that impacts your ability to work, not what that issue is. Maybe someone is suffering from depression. The question is whether that impacts their ability to work. That doesn't matter what the condition is specifically, what treatment they're getting, what medication they're getting, and what other opinions they're getting. Your doctor says there's a medical issue, you need accommodation. That's all your employer is entitled to know.
We are working our way through the duty to accommodate, true or false. Next one, Lior, for you is this. If accommodation proves slightly inconvenient, an employer does not have to implement it.
So an employer says, well, that's going to be kind of inconvenient. We just don't have to do that. We shouldn't be inconvenienced. False. Completely false. Your employer has to accommodate even if it's inconvenient, even if it's quite inconvenient, they still have to do this. In law, we call this accommodation to the point of undue hardship. What that means is that they have to accommodate even if it's hard. Now, at some point it becomes too hard, too difficult, too extreme, that they don't have to do that. If they have to open a brand new office across the street so you can be accommodated, that may be too far to go. But if they have to ensure that you work different hours, or if they have to ensure that someone is there to help you carry something that's heavy, that is perfectly appropriate, even if it causes some administrative issues. So oftentimes, way too often, I see employers that don't want to go far enough. Say, well, this is going to be a bit inconvenient. We're not going to do that. Can't do that. That's a human rights violation. So if you don't think your employer is going far enough to accommodate you, they don't want to, they're not trying, they're saying that it's too much, chances are what you're looking at is a human rights violation. You have to get on the phone and call me then right away.
Would I assume that threshold to inconvenience, it increases, it gets higher as the company or whatever the employer has more resources, bigger company, more money, more accommodation possibility? Yeah?
Absolutely. You can't really compare a company with one employee to a company with 10,000 employees. Clearly, the bigger companies are going to have more things that they can do, more options, more positions, more support that they can give. So don't get me wrong, the smaller companies also going to have a very strict obligation to accommodate, but their options may be more limited. So the bigger the company, the harder it is for that company to say, oh gosh, that's just too much.
Duty to accommodate, true or false? We'll get one more of these at you, Lior, then you can relax a bit. And it is a refusal to accommodate an employee is, as you mentioned, a human rights violation. That's a big red flag.
It's a big red flag. Of course, that is completely true. It's not just that it's the right thing to do. It's also the legal requirement. Our human rights laws say you have to accommodate. It's not a nice to have. It's not discretionary. It's a must. So if your employer doesn't do that, that's a human rights violation, which comes with consequences. There's payments that or damages that the company may have to pay. They may have to reinstate you. They may have to pay you back pay if you lost your job or they weren't allowing you to work. So there's all kinds of consequences for a human rights violation. That's why don't ever assume that the law is not on your side. When it comes to accommodation, especially if it's a medical issue, but not just that, when it comes to accommodation, the law is quite good, quite extensive, and does provide very good protection.
As we like to remind you, employmentlawyer.ca, the website, will give you a conduit to find a radio show across the country in your community that Lior and I and his other lawyers of the firm host weekly. You want to tune into those, and anytime you want to grab a phone during those radio shows, depending on the number, you can call in and ask some questions. Maybe your phone call will get played back here on this show, which we're going to do right now, Lior, with another phone call from the radio show.
How many letters or write-ups are required before it becomes with cause? And then part two of the question is, how far or how close do those letters have to be? So could one happen within year 3, for example, and then like 2 years later, second one happen, and would those be considered consecutive?
It's a great question. It's a great question.
It's a terrific question. And, it's hard to answer exactly specifically because there's no law that says it has to be this many letters and that much time. But let me give you some general thoughts. Before a company can and again, by the way, let's take a step back. We're talking about non-union employees here. Yeah. Very different for unionized employees. The collective agreement has the answer to those questions. But for non-union employees, generally speaking, we would want a minimum of 2, potentially 3 disciplinary measures before a company can consider firing someone for cause. So 2 or 3 warnings before the company is in a position to fire for cause legally. There's no jumping the queue. They can't say, well, you did something wrong today, we're firing you for cause. It doesn't work that way. And generally speaking, with less than 2 warnings, you almost never be able to terminate for cause. So 2, probably 3 before the company can terminate for cause. And those 3, let's call them 3 warnings, would have to be probably within the last 3 years for them to count. If you got a warning 10 years ago, that's not really going to matter. Your employer can't hold that against you. So within the last 3 years, those are some general thoughts. But remember, it is very difficult to terminate for cause. And most employers, when they terminate for cause, supposedly do it wrong. It's a wrongful dismissal in that situation. So if you believe that the company let you go for cause, or that's what they're telling you, even more of a reason to connect with me right away.
Love getting these phone calls from the radio show on the air, Lior. We're going to do another one, but we're going to break first, so we'll do that when we come back. The phone number to reach out to Lior and the team, 1-855-821-5900. And that email again, help@employmentlawyer.ca. Coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the show. You can always reach out to Lior and his team at pocketemploymentlawyer.ca as well. You want to get to the severance calculator, it's within that website, pocketemploymentlawyer.ca. But I want to get to our third phone call for the show. Lior, it's coming up right now.
I've been working at a small business for 12 years. I was told about 2 weeks ago that it was going out of business. I have this feeling that they have no intention of giving me anything.
Like, are they going bankrupt, or are they just shutting the business?
They're just shutting it down.
And how old are you?
56.
What type of job did you or do you have?
It's sales.
Important point you made in there. Very important point. Yeah.
Extremely important. There's a huge, massive difference between shutting down or stopping to operate and going bankrupt. Going bankrupt is a legal process, which means that you have way more debts than you have assets. Your liabilities exceed your assets, and you're in a formal process that protects you from having to pay an employee. So if a company is bankrupt, you're probably not going to get severance or any other payment if that's your situation, if you're an employee of that company. Very different than if the company shuts down. If they shut down, you better believe that they still have the obligation to pay. And you may be able to enforce that against their property, their assets, their equipment, their accounts receivable. So they have to pay, and they don't avoid that by saying the company is out of business. Not at all. What you want to do, of course, in that situation is you don't want to wait. You don't want to wait for them to sell their assets and have nothing. You want to deal with it as soon as you realize that the company is shutting down. And then, of course, they have to pay severance. So, of course, the last question here for this person from the radio show becomes, how much severance are they owed? So I can tell you, but let me show you how you can find out for yourself. We're going to go back one more time to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We're going to use the severance calculator, and let's see what this person is owed when their company is going out of business. So we know that she's been there for 12 years, 56 years of age. Company is not planning on paying severance. Well, too bad. You see in the bottom there that she's owed as much as 16 months of severance. 16 months. Company has to pay it. We deal with that all the time. Find yourself in that situation. Let's talk right away.
I know we got to run here, Lior, in about a minute and a half, but sales, you're thinking, okay, but it could be this. Your earnings could be up and down month to month, year to year. How do you calculate that severance?
Yeah, so not everyone makes fixed income. Some months are better, some months are worse, some years are better, some are worse. So how do we calculate severance for someone that doesn't have fixed income? It's actually very simple. We look at an average, and we use that average to calculate your severance. Depending on how long you've worked there, we may look at a 3-year average. If you worked there for only 1 year, we'll look at the full 1 year. So it's going to be an average to account for the fact that some months are good and some months are bad. Your employer may want to just look at the bad months. Doesn't work that way. It's going to be an average so that you get fair severance even in a situation where your income fluctuates.
And I guess if as your income scale was going up over the years, I guess you factor that in as well. But it's all the math done on your end for sure. But now that we are done, you want to reach out to Lior and his team anytime. Super simple, 1-855-821-5900. Help at employmentlawyer.ca for email. And again, pocketemploymentlawyer.ca, that invaluable website, free and anonymous, and rolled into that is the severance calculator. By the way, as Lior mentioned, 2 million plus people have used it and had their eyes open, so you can use that anytime as well. We'll catch you next time. Thanks for joining us right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.